Members of the jury, about 6:45 on the morning of April 27th, 2004, plaintiff in this action received personal injuries as the result of a collision with an automobile truck owned by defendant and operated by the defendant's employee. The plaintiff claims that those injuries were caused without any negligent act on his part contributing, and solely through the negligence of the defendant's chauffeur, which of course would be chargeable to the defendant. The defendant denies both of these claims. The claims of the plaintiffs and the defendant's denials constitute the issues in the case which are to be submitted to you for your determination. The word issue, of course, means dispute, and to determine the issue means to make an end of the dispute within the evidence. You are to do that by applying the rule of the preponderance of the evidence, and under your oaths you are not permitted to apply any other method or means of resolving these two disputes. Neither sympathy nor prejudice nor what you might think apart from the rules of law were fair, but please bear in mind that you are to continue yourselves to the use of this rule and preponderance of the evidence in making an end of these disputes. You have heard those words so often, perhaps it might be well to concentrate on them a minute and get over that feeling of familiarity which sometimes breeds anything but respect. The words preponderance of the evidence relate rather to the quality of the evidence than to the volume of the evidence or the number of witnesses. There are a few tests that you might apply in judging of the quality of the evidence. One of them is the rule regarding interested witnesses. Of course, the plaintiff is an interested witness. The chauffeur who drove the automobile truck is an interested witness. The plaintiff's wife is an interested witness. They are interested witnesses as a matter of law. You do not have to decide that, but it remains for you to decide whether any other witnesses in the case are interested witnesses as a matter of fact. It does not follow, however, that because a witness is interested, either as a matter of law or a matter of fact, that you are to disregard all the testimony of the interested witness. It follows only that you are to take note of the interest and judge for yourselves how much bias, if any, attaches to the testimony of the witness because of his interest. Another test to apply in judging of the quality of the evidence is the rule regarding false testimony. There, the rule is more severe. If you find that any witness in the case has deliberately testified falsely on a material question of fact, then you are free to disregard all his testimony. And another test to apply in judging of the quality of the evidence is the test of probability. You are naturally familiar with that. You probably resort to it daily in your occupations. What was the natural probable thing to have occurred here in the light of the evidence? Which is the more probable version as to the manner in which the accident happened? After you have applied these tests and selected what you regard as the credible evidence in the case, then put it aside, put it, so to speak, in the scales on your brain. Remember, at that point, that the burden is on the plaintiff to satisfy you by this preponderance of the evidence, that the accident happened in the manner in which he claims, that he was free from any negligence which contributed to it, and that the defendant's chauffeur was guilty of negligence which caused his injury. Very briefly stated, according to the plaintiff's version of the manner in which the accident occurred, he started to cross 8th Avenue near the southerly crossing of 23rd Street. He looked in both directions, and, looking to the north, he saw the defendant's truck approaching at a fast rate of speed. He approached the trolley tracks, and he looked again to the north, and he saw the defendant's truck near 24th Street. And then, estimating that it would be perfectly safe for him to continue at the rate he was walking, that he could cross without danger, he suddenly realized that the truck was approaching so rapidly, as he claims, that it was 4 or 5 feet from him, and before he could clear the southbound trolley car, he came in collision.